Hi, I'm Jim Covington, and I'd like to welcome you to this week's issue of ISBA Statehouse Review. I'd like to talk to you about 5 bills that have been passed by both chambers of the General Assembly and are in the process of being sent to the governor. If you're wondering the time deadline when the governor will take action, according to the Illinois Constitution, the General Assembly has 30 days to administratively send it to the governor from the date it passed the second chamber. The governor then has 60 days to take some kind of action. What does that mean is a lot of bills are going to be signed in July or August, or the governor will take action on them as the 60th date gets near, unless it requires an immediate effective date or something like that. He would take earlier action. The 5 bills I'd like to talk to you about. The first one is House Bill 5512, introduced by Representative Elaine Neckritz from Buffalo Grove and Senator John Mulrow from Chicago, and it stays the limitation periods for statute of limitations for personal actions until a person's disability is removed. If a person is not under a legal disability at the time the cause of action accrues, but becomes legally disabled before the limitation period expires. These changes do not invalidate any applicable statute of repose provisions and affect only actions commenced or pending on or after January 1, 2015. The second bill I'd like to talk about is House Bill 8, introduced by Senator Toy Hutchinson from Chicago Heights and Representative Mary Flowers from Chicago, and it amends the Illinois Human Rights Act to prohibit unlawful discrimination by an employer for pregnancy and requires employers to exercise reasonable accommodations to a job applicant or an employee for issues concerning pregnancy or childbirth. And that also has been sent to the governor. The next bill I'd like to talk to you about is Senate Bill 3228, introduced by Senator Bill Hayne from Alton and Representative Ann Williams from Chicago. It is a major rewrite of the power of attorney for health care law that does a number of things. It replaces the current statutory notice and form, and in the notice it sort of redoes it in sort of a modern day FAQ for people that are reading this thing, the principal and the agent. It also changes the form itself to try to make it more user friendly and readable. It clarifies that a witness must be at least 18 years of age, and employees who are not owners of a healthcare facility may serve as a witness, specifically listing chaplains, social workers, and nurses. All other medical professionals are excluded. The Savings Clause provides that Senate Bill 3228 doesn't invalidate existing powers of attorney for health care, and it also contains a safe harbor that it retains current law that authorizes principals to use other forms instead of the new statutory form as long as they comply with Illinois law. The fourth bill I'd like to talk about is Senate Bill 1098, introduced by Senator Don Harmon from Oak Park and Representative Barb Curry from Chicago. And it amends several acts governing business organizations regarding director and liability during periods of dissolution. Reinstatement of the organization reinstates the corporate liability shield for directors, officers, employees, and agents of the organization for actions taken during the period of dissolution. And it clarifies that directors are not liable for actions that are necessary and appropriate to wind up and liquidate a corporation's business and affairs. The final bill I'd like to talk to you about comes from the American Association of Law Libraries. It's Senate Bill 1941, introduced by Senator John Mulrow from Chicago, Representative Mike McAuliffe from Chicago, and it creates the Uniform Legal Material Act to regulate the authentication, publication, and availability of Illinois' legal sources in electronic format. As more and more of our primary sources of law are being distributed by electronic format, the law librarians, in conjunction with the Uniform Law Commission, decided that it might be an appropriate thing to sort of put out there the rules of the road on, authentication, publication, transferring, all that. If the governor signs it, Illinois will be the 9th state in the country to adopt that. Thank you for tuning in, and we will see you next week.